what is expropriation? I would say expropriation is basically taking property from a private owner for a public interest. So it's a government instrument used to acquire property for public interest. Technical term, I would say, is a coercive appropriation of private property by a state. And this action is rooted in government sovereignty, which grants government authority over property and resources within its jurisdiction for economic, political, or social objectives. So generally, expropriation by the international law standards should meet certain criteria. It should meet certain requirements, and it should meet the requirement of public interest. So the property or the said property that's going to be expropriated must serve a legitimate public purpose. It should be strictly public, not political. So it should be for the public, for the government, or for the nation. So secondly, it should not be biased. It should not be discriminatory. It shouldn't target a particular people, like a particular group of people. It should be fair and just. And it should also follow the due process. So expropriation must adhere to established legal protocols. And it should go through the ranks. It should go through all the steps to acquisition. And compensations being paid for expropriation or after expropriation should be prompt, adequate, and effective. So expropriation is actually broad. It's very broad, but can be categorized into two different types. So the first type is direct expropriation, and it involves the outright acquisition of the property, resulting in the owner losing nearly all control over the property. So loses almost every right over the assets. And the other type, which is indirect expropriation, it involves actions that significantly diminishes the property's value or utility. So it diminishes the value. There are actions that diminish the value or the use of the said property. Such actions are restrictive regulations by the government or forced administrative measures. So in Germany, expropriation is governed by Article 14, Section 3 of the Court Gazette, which mandates that expropriation serves public good, follows statutory procedures, and ensure fair compensation. Other complementary statutes like the Federal Building Code, Bar Gazette's book, specifies or defines specific processes of expropriation. There are two major phases of expropriation. The first phase is the planning phase, and the second is the expropriation phase. So under the planning phase, there are two main stakeholders, which is the municipal authorities and the public. So the municipal authorities create binding zoning plans. They create balancing interests and consider other alternatives, whilst the public are also given the opportunity by the Bar Gazette's book, Article 1, Section 7, and Article 3, Section 1 to 2, give the public the mandate to assess the draft plans and are also given the opportunity to justify and give feedbacks to the drafted plans. The expropriation phase, authorities verify legality and proportionality of expropriation to ensure compliance with the Bar Gazette's book, Section 85. And then the affected parties are formally notified and may inspect the procedural documents. Conclusion: the German laws on expropriation showcases a detailed balancing of public and private interests under the Constitution and international laws. A case study is the Kozow Factory von Malten and Prince Hans Adams II case, which highlights key principles including proportionality, fair compensation, and the challenges of historical claims. These frameworks have gone a long way to emphasize the importance of public participation, transparency, and equitable treatment in modern expropriation practices. Thank you.